Senator McPhedran.
Thank you very much. My question is short. Would you take my question, Senator Dean?
Yes, of course.
Thank you. I want to recognize your long years of service in government at the highest ranks of civil service in Ontario, and therefore I think I'm quite safe in assuming that you were involved many times with the creation of regulations that had been promised in bills. Would I be correct in that before I pose my question?
You most certainly would. Please continue.
Thank you. Thank you. In your long experience, was there ever a time when regulations were promised to accomplish something and either the regulations never happened or the regulations did not, in fact, sufficiently meet the promised goal that was raised at the time of the Act?
My experience is that in some cases regulations were promised. Sometimes they were promised and varied and were not completely in concert with what people were hoping for or expecting. And in some cases they weren't delivered at all. In this case, I think when there is a spotlight on an issue such as the vulnerability of children in our immigration and asylum system, I'm, as an individual, as a senator, prepared to accept the minister at her word when she says she will deliver such regulations. Thanks for the question.
Senator McPhedran, supplementary?
Yes, please. Would you accept a supplementary from me, Senator Dean?
I would, yes.
Thank you very much. So thank you for that answer. I think it's a very helpful exposition of the range of possibilities that occur around regulations. And I want to point out, one, that we have seen in the almost 10 years that I've been in this chamber, and you've been in this chamber, numerous times when regulations that were promised either did not meet the promise or didn't happen at all. And I would point out also that reliance on a particular minister is it not highly problematic? We see changes in cabinet all the time, and we see new ministers coming in and not being bound by any promises of a minister who made the promise. And I would cite as a particular example, because I'm sure you paid close attention to its journey through this chamber, and that is the Canadian Disability Benefits Act. And the way in which regulations have either not happened at all, or when they have happened, they have been a massive disappointment to those who rely on the regulations to actually give them something that they desperately need. So may I frame my question, my supplementary, this way? Do you think it is possible that in this Act, with the promised regulations, there is a possible scenario where either those regulations don't happen as promised or they do not meet the goal promised? Senator Dean.
That's a theoretical question, and I'll give you a theoretical answer. I theorise that in this particular circumstance, I have confidence, given what I've been told and what has been committed to me, that these regulations will emerge. Without them, there will be a considerable spotlight on the minister and the government by virtue of the vulnerability of the subjects of the regulation. So I believe that they will emerge, Senator McPhedran. And while I'm on my feet, let me return the compliment and say thank you for those kind words about my career. I would like to also recognise your long career and storied career that goes all the way back to the roots of a particular march that occurred recently. And you are well known for that, and your reputation is widely known and admired, and I'm glad to be able to say that to you.
Senator Matters. Senator McPhedran on debate.
Thank you very much, Your Honor. Je tiens à remercier la...
I'd like to thank Senator Youance for her amendment. A very complete amendment to this scandalous bill. It is a negative bill that will hit tens of thousands of people, especially young people.
For unaccompanied minors that we've heard here, it's important for all of us to remember most children cross with their parents, so very few children can be supported through the government approach that is being promoted here. The excellent amendment from Senatrice Youance is the way to actually protect young people and children. The CRC, the Convention on the Rights of the Child, has been mentioned by numerous speakers. It is a virtually universal reference and instrument, as it is the most ratified treaty in history, with 193 states parties. To be truly effectual, the Convention depends on effective application, especially in domestic law. But full implementation of the CRC by all states parties is still problematic, less so in Canada than some other countries. In principle, every state party is responsible for acting on its international commitments, its international obligations, and may not rely on the provisions of its own domestic law to avoid the obligations it has assumed under the treaty. While the Convention on the Rights of the Child has not been incorporated in Canadian laws, this convention was in fact cited 5 times in the Supreme Court of Canada between 1993 and 1996. But up to that point, it had not really had much effect. Then came 1999. And the Supreme Court judge, only the second woman ever to be appointed to the Supreme Court, Madam Justice Claire Dubé, sometimes known as the Great Dissenter, wrote an opinion in the Baker case in 1999, and that put the Convention on the Rights of the Child through the door of the Supreme Court of Canada in allowing references to the Convention in a contextual approach to statutory construction and in judicial review proceedings. For those of you interested in how the law operates, this is a pretty big deal to have this happen, and it was entirely based on a child-centered analysis by a woman judge. Since then, there have been several other decisions of the highest court that have addressed the question of the Convention on the Rights of the Child and expressed some openness to continuing to use it for interpretive purposes, not only with regard to the Canadian Charter of Rights and Freedoms, but also for ordinary statutes, in particular, youth protection. So in speaking in favor of this amendment, I thought it might be helpful to remind this chamber of what the Convention on the Rights of the Child actually says and actually does, and to implore every one of you to think about our obligations to the children of this nation today and to come. Thank you very much. Merci, miigwech.
Senator McPhedran, you have a question?
I do. Would Senator Harder take my question?
Of course.
Thank you. Senator Harder, I have no doubt, being such a learned man, that you're familiar with the book, The Origins of Totalitarianism by Hannah Arendt. Am I correct?
You are indeed.
Thank you. When you mention the IRB and you state your confidence, let me assure you, as a member of SOCI, we share that confidence. Unfortunately, this draft law will take away much of the jurisdiction of that board of which you think so highly and we think so highly. And there are all kinds of people who now would have access to that very excellent and fair process who will be shunted over to this PRRA with officials within the bureaucracy who do not have the training, who do not have the independence, and the result of this will be a denial of basic human rights that Canada has prided itself on in protecting refugees, in respecting international law on refugees. And this bill is retrograde. This bill allows the cabinet of this country, to do what we did to the Jews on the ship St. Louis, to do what was done to Japanese Canadian citizens. That brings me back to my question using Hannah Arendt. One of the signs that she wrote about the rise of totalitarianism, what to look for, was the removal of citizenship from certain identified groups. This bill allows massive cancellation of permanent residents, people that have lived here, people that own homes, people that work, people that pay taxes, people that have children that need to go to school. And this allows the cabinet of this country. So may I ask whether you factored that in to your great trust in the framework that is laid out in this bill?
Senator Harder.
In a word, yes. In two words, let me say that the bureaucrats, the officials that you seem to be disparaging with your comments in the department are the same officials and the same departmental officials that have managed refugee flows of those selected overseas or managed our immigration selection system. So, yeah, I have confidence in them. They will do the work that legislation authorizes them to do, and they'll do it in an impressive fashion. You know, when the Immigration Refugee Board was appointed, they were accused of being partisans because they were appointed by orders in council, as opposed to bureaucrats, which are appointed through the Public Service Commission. I found both descriptions disparaging, and I tend to have a more gentle view of humankind.
Thank you. Okay. There's 1 minute left for Senator Harder's speech.
Question, just for clarification. So the IRB, the board of which you helped to create and you stated such faith in, the acknowledgement that you've made in the answer to my previous question is also an acknowledgement that that board will no longer be the deciding body in many of the cases that currently it is the deciding body. And the shift over to the PRA, and I really reject the adjective cynical. You know, you've spent your life in government. I've spent my life as an advocate, as a human rights advocate, and I've seen all of this before. So I need to understand why you're so prepared to let go of the jurisdiction and the expertise of the IRB.
Senator Harder, you have 13 seconds.
Well, I guess I will be brief. I have confidence that the officials involved in the PRRA process will be well trained and perform their functions. Having said that, in all of my meetings with the advocates who came to me with their concerns about this bill, I urged them at committee to get commitments with respect to the resourcing and the transparency around the PRRA.
Senator Harder.
The success of this bill.
I'm sorry to interrupt, Senator Harder. Your time has expired, but are you asking for more time to answer questions? No. Okay. Are senators ready for the question? In amendment, it was moved by the Honourable Senator Youance, seconded by the Honourable Senator Surette, that Bill C-12, as amended, be not read the third time, but that it be further amended in Clause 73 on page 34 by adding the following after line 14. Suffit?
Dispense.
Is it your pleasure, honorable senators, to adopt the motion in amendment? Yay. All those in favor of the motion, please say yay. Yay. All those opposed to the motion, please say nay. Nay. I think the nays have it. I see two senators rising. Do we have an agreement on the length of the bell? 15 minutes?
15 minutes. Is leave granted?
Is leave granted, senators? Leave is granted. So the vote will be at 4:47. Call in the senators. Senator McPhedran.
Thank you very much, Your Honor. I would also like to speak in support of this amendment, and I would like to call upon all of us in this chamber to think a bit more about the nature of the reporting of a standing committee of the Senate, reporting back to the Senate, and that it is not often that we see a standing committee of the Senate make proposals to the Senate that are completely rejected. This is a unique, not unique, but this is a particular situation, and I would ask us to think on the implications of that. Senators heard from Dr. Moody, the chair of SOCI, that the senators on that standing committee fulfilled its mandate to be the only Senate committee to report back to the Senate on parts 5 to 8 of Bill C-12 by meeting for over 13 hours with 35 witnesses and 36 written submissions, something that the counterpart in the other place did not do. The committee heard from refugee advocates, legal experts, civil liberties organizations, practitioners in immigration, refugee lawyers, and people with lived experience, and we respected them as having expertise. We heard from Amnesty International, the Canadian Bar Association, the Canadian Civil Liberties Association, and the United Nations Refugee Agency in Canada, and they all raised concerns that parts 5 to 8 of C-12 represent an infringement of human rights, of privacy protections, of procedural fairness, and of constitutionality. The amendment before us from Senator Simons is parliamentary protection against an overreach of executive powers. SOCI reported to this chamber grave concern that such overreach may disproportionately impact children, 2S LGBTQI persons, women, and frontline service providers. On behalf of the senators on SOCI, Senator Moody urged this chamber to give careful consideration and robust scrutiny to examine the legislation not only for its policy objectives, but for its consequences on democratic governance and on the lives of people that this country needs. In the case of Senator Simon's amendment on the negative resolution of power and use of the Interpretation Act to activate parliamentary scrutiny to build on the amendment from the House, I ask honourable senators to think carefully about sidelining Parliament. And I'll do that by quoting the sponsor, Senator Dean, that the bill as now worded applies to, quote, any form of crisis, end of quote. So crisis could apply to anything that the Cabinet decides is a crisis. Just as governments in regressive regimes, including the one south of us, define a crisis when citizens rely on constitutional protections of freedom of expression and freedom of assembly. Let me invite you not to indulge in the arrogance of thinking that these violations of the rights of citizens could never happen here, because Canadian cabinets have already breached the rights of citizens. I have been honored in Winnipeg and different parts of the country to work with Japanese Canadians on reparations for being stripped of their land, their communities, their citizenship, because the cabinet of the day defined it as a crisis that these people were citizens. And those reparations have been led by people like Art Mickey from Winnipeg and Justice Mariko Amatsu, the first Japanese-Canadian woman to become a judge. Let me also address some of the stereotypes employed by some senators on debate directed at senators who question this bill. May I remind you, colleagues, that we took an oath when we entered this chamber. I actually entered this chamber to take my oath with Senator Harder. It was not an oath to serve any political party. It was not an oath to serve the cabinet. It was not an oath to serve the government. We have taken an oath to serve this nation, this democracy. This amendment by Senator Simons is a safeguard for democracy and parliamentary exercise of our obligations to this nation. I invite you to take your responsibility as a guardian of our democracy and support this amendment. Thank you. Merci. Miigwech.
Les sénateurs sont-ils prêts pour la question?
Are senators ready for the question? In amendment, it was moved by the Honourable Senator Simons, seconded by the Honourable Senator Wu, that Bill C-12 be not now read a third time, as amended, be not now read a third time, but that it be further amended. Dispense.
Question. Is it your pleasure, honourable senators, to adopt the motion? All those in favour of the motion, please say yea. Yea. All those against the motion, opposed to the motion, please say nay. Nay. To my opinion, the nays have it. I see two senators rising. Do you have an agreement on the length of the bell? 15 minutes. 15 minutes. Is leave granted? Agreed. Leave is granted. So the vote will happen at
6:13.
6:13. Call in the senators. Senator McPhedran, you have a question?
Would Senator Pupatella take a question?
Thank you, yes.
Thank you. My question is in the context of Canada taking less than 2% of the world's refugees. And my question relates to your saying that Senator Mohamed's amendment could, quote, upend the entire system, quote. I completely do not understand that, and I would ask if you could give some specific examples of how Senator Mohamed's amendment is going to upend the entire system.
Senator Pupatello.
Thank you. Well, I think I did mention that should we enact a sunset clause, and it's scheduled in 5 years from the date of royal assent, in 5 years, considering the last 20 years we've had minority governments, we never know when we're having an election, we never know how long a session is, when this parliament is prorogued. We can't say with certainty that we will be here in a year, for example, because we were in that uncertainty right now. So in 5 years, when that review is to be tabled, what state are we in? And if you don't do the review, do you then completely wipe out that entire act? Actually, yeah, because it's being sunsetted with this clause. So all I'm suggesting is that when you're dealing with Parliament and it is uncertain, I think you've got to give them the means to do their job, which is not to have a sunset clause. Thank you.
Honourable senators, it is now 7 o'clock, and pursuant to Rule 3-31 and the order adopted, I'm obliged to leave the chair until 8 o'clock unless the senators agree to not see the clock.
Honourable Senators, leave was not granted. The sitting is therefore suspended, and I will leave the chair until 8 o'clock p.m. Is it your pleasure, Honourable Senators, to adopt the motion in amendment? Yes. All those in favour, please say yea. Yay. All those opposed, please say nay. Nay. In my opinion, the nays have it. I see 2 senators rising. Do we have an agreement on the length of the bell? 30 minutes. 30 minutes. Is leave granted? Agreed. Leave is granted?
I heard a no.
I hear no. Do we have an agreement on the bell? If we don't have an agreement on the bell, it's going to be 1 hour. No. Honourable Senators, please. Do we have an agreement on the bell, on the length of the bell? 30 minutes. Do we have? Is leave granted? Yes. 30 minutes. Leave is granted. So the vote will happen at 8:38. 8:38. Call in the senators.